2322. Both of those bills will not be heard this evening. They're going to be heard at a later date. Senator Jabour moves to hold for further study both bills, seconded by Senator Lynch. All in favor signify by saying aye. Aye. All opposed? The numbers are bill number 2231 and 2322. What we'll do is Senator Archibald should be up here. I did indicate to Senator Archibald, because he has so many bills that are on the same subject, we'll hear all those bills at one sitting as soon as he gets up here. The first bill we'll do is bill number 2223 by Senator Picard. Is there anyone present who would like to sign up to speak on that bill? Hearing none, Senator Jabour moves to hold for further study, seconded by Senator Lynch. All in favor signify by saying aye. Aye. Opposed? The bill is held for further study. The next bill we'll do is Senator Raptakis' bill, bill number 2366. Senator Raptakis, if you want to endeavor to explain.
Thank you, Mr. Chairman. What this bill does, Mr. Chairman, the high-speed, I don't have it from the high-speed chase bill.
This is your reckless bill, reckless driver.
What this bill does, Mr. Chairman, it makes high-speed chasing. I got to pass this up. Into a felony in Rhode Island today. Anyone that causes a high-speed pursuit is deemed only a misdemeanor. And a lot of these high-speed chases end up in danger for the motorists of Rhode Island, the innocent folks that drive along our highways, and these individuals just don't care. Some of the articles and some of the stories, police pursue through 7 Rhode Island municipalities, ends with arrest of a Woonsocket man in Cumberland. This individual was in a crime of an armed home invasion, stole a vehicle, went through several cities and towns, sideswept another vehicle, crashed his vehicle, and then went ahead and stole another vehicle. And the danger that occurs during these high-speed chasing is out of control. And some of the stories that we hear places a lot of Rhode Island motorists in danger. And police do have a policy, Mr. Chairman, ladies and gentlemen of the Judiciary Committee, not to pursue. A lot of these cases, they back off and call off a pursuit. But some of these cases, like I said, either armed robbery, home invasion, some serious crimes that take place are pursued. And I believe that the time has come where we make a high-speed chasing not just a misdemeanor, but make it in a felony.
Are there any questions or comments for Senator Raptakis? Senator Metz.
Yes, Senator Raptakis. On this, if the high-speed chase, I can understand if there's a certain amount of damage, it would automatically be a felony anyway, as it stands now. Am I right about that?
The reckless driving portion is not, Senator Metz. That's a key issue where these individuals cause these high pursuits, and a lot of times the act where they're being pursued at a high-speed rate, say, for example, 80, 90, 100 miles an hour, the reckless driving portion is only a misdemeanor. So,
and Senator, the reason why I asked that, if there's no damage, no one's hurt, so does this have any discretion for the judge?
Senator Metz, I'm not sure if it does, but if we can look at a sub-A and allow the judge, I'm for allowing the judiciary discretion when it comes to convicting somebody or charging somebody with a felony.
Thank you, Mr. Chairman.
Are there any other questions or comments? The next witness we have is Steve Brown. Going to vote on it. Good afternoon and welcome, Mr. Brown.
Thank you, Mr. Chairman, members of the committee. On behalf of the ACLU of Rhode Island, I'm here to express our opposition to this legislation. I certainly agree that high-speed chases can be very dangerous. The ACLU has actually done some reports in the past looking at the problem of high-speed pursuits. But what the studies routinely show is that high-speed chases, first of all, are often done by young people, teenagers, young adults who are simply being pulled over for a traffic violation, a minor violation. It isn't as if they're hiding something, but they impulsively speed off. And the key issue for us is, what do the police do? Senator Raptakis is correct that many police departments now do have much more stringent policies in place. Before, high-speed pursuits were just routine. Now, at least in theory, they are supposed to be conducted only to pursue suspected felons and so forth, although we find that isn't always the case. We believe that the laws that are already on the books that Senator Metz has pointed to are sufficient, that by making pure eluding a police officer a felony imposes too harsh a penalty, and for that reason we'd urge the committee to let the other laws be used to address this sort of conduct rather than make more young people felons. I'll be glad to answer any questions.
Are there any questions or comments for Mr. Brown? Senator Raptakis.
Steve, do you have statistics that say that this year in Rhode Island we had, say, 15 high-speed chasing incidents, and out of those 15, the majority of them were teenagers? Because the articles that I have in front of me, a 26-year-old, a 39-year-old. So do you have statistics that said there was X amount of high-speed chasing incidents in Rhode Island and that the majority of them were under 18 years of age?
I don't have any statistics for this year for Rhode Island. I can present some national information about that, though.
Well, we want Rhode Island because it's a Rhode Island law. It's not a national bill, so
I understand, but I don't think there's any reason to believe that, as a general rule, Rhode Island would somehow be a lot different from elsewhere.
Well, because other states do charge as felonies when high-speed chasing, first offense is a felony. So that's why we're trying to make this a little bit tougher, especially the crime that occurs, the bodily injury that occurs, the destruction that occurs. I mean, you've got these individuals going through 2, 3, 4 communities. They don't want to stop because they know that they've caused other crimes.
I understand. You know, when bodily injury occurs, there are laws on the books that make that a felony right now.
Senator Lombardi.
Thank you. Yeah, that's a perfect segue, Steve. I'm a little concerned, as someone who practices in the courts, that we're going down a slippery slope here to redefine and redefine and redefine crimes when similar fact patterns can be placed under the umbrella of a previously existing statute. So, for instance, Senator, the pursuit into municipalities leading an arrest in Woonsocket and Cumberland, that there were guns involved. There was assaults involved in that case. The East Providence involving a teen, by the way, 17-year-old, involved 6.3 pounds of marijuana and a loaded handgun. So, the speed in and of itself, I think the result of that speed, I think, is already codified within our statutes. And I fear that we're going down this slippery slope of just adding unnecessary definitions to crimes that basically already exist on the books.
Are there any other further comments or questions? Thank you. With that, Senator Jabbour moves to hold for further study. Seconded by Senator Lynch. All in favor signify by saying aye. Aye. Opposed? The bill passes. The next bill we're going to do is bills held for further study. The next bill, I was looking at Senator Cisnowski's bill. I'm ahead of myself here. The next bill we're going to do is Senator Cisnowski's bill, bill number 2255. This is a bill which we previously heard. This is the hands-free personal wireless devices. Senator Jabbour moves passage, seconded by Senator Lynch. All in favor signify by saying aye. Aye. Opposed? The bill passes. The next bill we're going to do is bill number 2424 by Senator Picard. We do have one witness signed up to speak on the bill. Kelly Sheridan, if you want to come forward.
Thank you, Mr. Chairman. Kelly Sheridan on behalf of the Guaranteed Asset Protection Association. The purpose of this bill is to clarify the legal authority of auto dealers to issue auto loans that include a debt cancellation provision. The debt cancellation provision refers to this problem, sometimes called the gap coverage, where if a car is totaled, the insurer's obligation is to pay the fair market value of the vehicle. There are times where the fair market value of the vehicle is less than the outstanding indebtedness on the car loan, in part because cars depreciate in value faster than the loan is amortized. So there's numerous products on the market to cover this gap. One device is for lenders to agree to a debt cancellation provision where, in essence, what the lender agrees to is in the event the car is totaled, the lender will accept as payment in full the amount paid by the insurer and will essentially waive or cancel the debt to the extent there's any excess debt. The federal courts have ruled many years ago that state insurance regulators cannot regulate debt cancellation provisions in the loans issued by federal banks and credit unions pursuant to their insurance laws. Following that, the state Division of Insurance of the Department of Business Regulation issued a bulletin 2009-3 that extended that same protection to state-chartered banks and credit unions, essentially stating that debt cancellation provisions are not insurance and will not be regulated as insurance. That bulletin was issued consistent with the general state policy that state banks should have the same powers and duties as federal banks. That's codified in state statute. The purpose of this bill is to extend this same protection when the loan is issued by an auto dealer rather than a financial institution. Auto dealers are not covered by Insurance Bulletin 2009. Only state banks are. The purpose of the bill is to extend it to auto dealers. We have the second purpose of the bill is we've included numerous consumer protection provisions, including a provision that it has to be at the option of the debtor. It has to the fee for this coverage has to be separately stated. There needs to be a free period where the person can cancel it without any charge. There's mandatory disclosures, some just basic core consumer protection provisions. We have shared the draft before it was introduced with the insurance division. We've received some input. We are in the process of working out language with the Division of Insurance. We are confident that we can reach agreement on the language that will satisfy the department's issues. And we've assured the department that we will not ask the committee to pass the bill unless and until the department is satisfied with the language. So with that, I will stop, and I'd be happy to answer any questions.
Are there any questions or comments for Mr. Sheridan? Hearing none, Senator Jabour moves to hold for further study. Seconded by Senator Lynch. All in favor signify by saying aye. Aye. Opposed, the bill's held for further study. The next bill we'll do is Senator O'Neill's bill. Excuse me. Bill number 2406. Senator O'Neill, if you wish to come forward, please. Good afternoon and welcome.
Thank you, Mr. Chairman and members of the committee. This was actually requested by a constituent, but I did not indicate so I take responsibility for the bill. So having said that, I think it's really a good idea. We do have one person here, I believe, to testify, but it's really about protecting runners, joggers, and people in the road where cars are passing them by. And what it essentially does is it puts that into the to the statute that to include joggers and runners, and also defines due care in this case, and that is to require the driver to leave at least 3 feet between the driver's vehicle and what the driver could reasonably anticipate the pedestrian's position will be. As you're approaching the pedestrian in the car at, say, 30 miles an hour, and somebody's running on the same side of the road, what this asks that a minimum of 3 feet be maintained between the vehicle and the pedestrian or the jogger or the runner.
Thank you, Senator. We do have one witness signed up, Barry Schiller. Mr. Schiller, if you'd like to come forward, please. Good afternoon and welcome.
Providence, and I've been involved in transportation advocacy for a long time, and I've made the point that we all have a societal interest in promoting safe walking, both because it's good for the environment and for health, and also because we're all pedestrians at times, even when we drive. So I think it's fair to call attention to the need for motorists who have thousands of pounds of steel around them to be sensitive to pedestrians in the road and keep a safe distance. I think that the 3 foot is a reasonable guideline. For that, we have a similar safe passing of bicyclists already in the code. So this would do it for pedestrians. And it's fair to call attention to pedestrians. I'm involved in a traffic safety coalition. I could tell you that for example, in 2013, of 65 road fatalities, 14 of them were pedestrians. The next year, 2014, out of 52 fatalities, 16 were pedestrians. That's almost 30%. Last year, 2015, I haven't seen it in writing, I believe 8 out of 45 fatalities were pedestrians. So it's fair to call attention to pedestrians. I myself like to walk, and I'm also a frequent bus rider, and that means crossing the street at bus stops. And so it would be nice to have this protection. I don't think it's something that will be enforced very often, but we could call attention to it in driver education. We could call attention to it in the code when people review the code for their driver's tests. And I think it makes some sense to have a safe passing guideline for pedestrians. Thank you.
Thank you. Are there any questions or comments for this witness? Thank you. Senator Jabbour moves to hold for further study. Seconded by Senator Lynch. All in favor signify by saying aye. Aye. Opposed? The bill's held for further study. The next bill we're going to do is Senator Metz's bill, bill number 2376. Senator Metz, if you wish to endeavor to explain.
Yes, this voluntarily would allow people to have on their license if they have diabetes, epilepsy. So in case they were knocked out and unconscious, whatever, the medical people would look at their license and have a clue as to what their various illnesses are.
There is one witness signed up to testify. Mr. Brown, if you wish to come forward, please.
Thank you, Mr. Chair, members of the committee. We don't have a position on this bill, but we did want to just throw out a couple of caveats. We understand the legitimate intent behind this bill, as well as the fact that it is voluntary. But we just point out that driver's licenses are shared with many individuals, many entities, and people may not realize who they may be sharing their medical information with when they hand their driver's license over for various types of identification purposes. Secondly, another potentially worrisome thing is what the DMV itself, whether the DMV itself will end up punishing individuals because they have sought to have this information placed on their license. You know, based on past experiences we've had, I would not put it past the DMV to see somebody coming in asking that, for example, there be a designation that they have epilepsy placed on their license, and then all of a sudden they're being called in and asked as to whether they actually are fit to be driving. So I just think people ought to be aware of those potential unintended consequences with legislation like that. But as I said, we don't have a position on the bill per se. Thank you.
Are there any questions or comments for Mr. Brown? Steve, maybe you can talk to Harold in the next couple of weeks about some of those issues to see if there's anything that can maybe be worked out in one way or another.
I'd be happy to.
With that, Senator Jabbour moves to hold for further study, seconded by Senator Lynch. All in favor signify by saying aye. Aye. Opposed? The bill's held for further study. The next bill we're going to do is Senator Nesselbusch's bill, bill number 2425.
Thank you, Mr. Chairman. As some of my colleagues here know, I have the privilege and honor of sitting as the municipal court judge in the city of Pawtucket, and I see countless motorists come before me for an inspection violation, and they say things to me like, oh, I just borrowed the car to take my children to daycare or to school or for some other purpose, and I didn't realize that the vehicle I was driving was uninspected. And so for years, I have lectured them that it's every driver's responsibility to know whether or not an automobile that they are driving is or is not inspected. But I must admit that over the years, as I make these pronouncements in court, the thought has occurred to me that it is actually the owner, the registered owner of the vehicle, who is in a much better position to ensure that the vehicle is inspected. And so it seems to me that, you know, when you get your first inspection or when you buy a car, you know, you sort of make a mental note as to when your vehicle needs to be inspected, and that, in fact, it is typically the registered owner who is staring at the inspection sticker, you know, each and every day that they use the car, and that, you know, though I could see some situations where a registered owner, the car would actually be used by a family member or friend, but on balance, I think that it is better to have the registered owner be responsible for that rather than any motorist who might drive the car. And that is why I put in this legislation, and I actually am interested to know what my colleagues think as well. So thank you, Mr. Chairman.
Are there any questions or comments on this legislation? There's no one signed up to testify. At this time, Senator Jabour moves to hold for further study. Seconded by Senator Lynch. All in favor signify by saying aye. Aye. Opposed? The next bill we'll do is Senator Pachato's bill, bill number 2367. We do have Steve Brown present to testify on this bill. 2367. That's a mistake? Okay. With that, Senator Jabour moves to hold for further study. Seconded by Senator Lynch. All in favor signify by saying aye. Aye. Opposed? The bill is held for further study. The next bill we'll do is Senator Gallo's bill, bill number 2402. And this is a duplicate to a bill that we passed last year that got held up in the House relative to driver retraining courses. There's no one here to sign. Senator Jabour moves passage, seconded by Senator Lynch. All in favor signify by saying aye. Aye. Opposed? The bill passes. The only bills that we have left are Senator Archibald's bill. We do have a couple of people signed up to speak on the bills. So why don't we start the hearing on Senator Archibald's bills, and then when he comes in, he can join in the conversation. We have Michael DeLauro, Hillary Davis, Joey Lenbeck, you can speak on all the bills at once, since in one form or another they relate to same or similar issues. And we'll start with you, Joey.
Thank you, Chairman. Our comments are directed primarily to 2370 and 2372, which involves the interlock legislation that Senator Archambault has proposed. We are not taking positions on the other bills. There are portions of this bills that we are happy with, and others that we do have concerns with. On page 2, the sections amended there, we know that this has been a concern of law enforcement. So, 2370 on page 2, the provisions on lines 12 through 18. We have been reviewing them. We think that this is something that law enforcement has been looking for. So we're appreciative of this provision. That being said, when it comes down to where we're at on 3127.2-8, and that's on page 12 of 2370 and also addresses 2372, When the interlock bills passed in 2014, the rationale behind that was there would be a hard suspension before the interlock provision took place, because that would give the offender the amount of time to get the interlock installed. We wanted, and the General Assembly, I think, concurred, is that we wanted to give people the ability to drive. However, we needed to get interlock set up. And that's why the hard suspension was put in there. This bill contemplates having the conditional hardship license go into effect at the preliminary suspension on a refusal. We don't think that's in the best interest of highway safety. The way the bill was passed originally by this body was that we would do a hard suspension, the conditional license would be granted upon the installation of interlock, giving a punishment of hard suspension, and then allowing a person to go on with their lives while still being on an interlock restriction. By allowing that conditional hardship at the arraignment, there's no ability to have that interlock installed. We think that these hours between the initial driving offense and when the interlock installed is a very crucial time for drunk driving. So we do not think this is in the best interest of public safety. I would state that we don't have a great deal of concern with the extension to other classes under the conditional hardship. I think that we can all recognize that our citizens have many things they need to do in their daily lives, including medical appointments, and we are generally supportive of that provision. This bill takes away discretion from the judiciary, and I know that we've had many conversations in this committee room about discretion and the importance of giving our judges discretion. This takes discretion away too, but it does it on the opposite end. We think that it's very important for the judges to have discretion in these cases to, one, limit the hard suspended time before the interlock is put in, and two, to have the discretion to enter a conditional hardship license. This bill mandates that, and we think that it's important for the judiciary to have that discretion dependent on the facts surrounding the case of the driving incident.
Don't they have that in the language here? Because isn't there after a finding of eligibility? Shall? So they have to find the eligibility first before they can get to the next step. Like that's the discretion of the judge, too, in determining the test on the eligibility for it.
I believe. I don't disagree with you, Chairman. I think there is discretion on one. I think there's a look at eligibility, but I think that after that point that there is no discretion. Where the bill as right now states that even though there might be reasons for eligibility, the judge can still deny. So I think you're correct, and then both of us might be looking at the same thing the same way. On page 14 of the bill, sorry.
Senator Lombardi.
Thank you. Joey, there still has to be a finding of need.
Right.
So you're going to have that discretion built in at the earliest phase of the procedure, of the process, if you will. So what this bill, as I read it, is at the arraignment stage, so to speak, you can come in and make your plea for the need for a hardship license and the installation of an interlock. The judge still has to go through the or the magistrate still has to go through the machinations of finding that need and what it is. Typically, I've used, they work 10 hours a day and they've got to travel from Warwick to Providence and yada, 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 those kinds of things. So the judge has to go through that process. It's not, you're not taking away his discretion at that point, or her discretion at that point.
You are in the fact that they could deny the need. It could be, while you do have you do have a 10-hour-a-week job that you may lose because we're putting a preliminary suspension on your license, because you don't have the interlock set up, and because of the incidence of your offense, I deny the hardship. That discretion is a discretion that's taken away.
Maybe we're talking about the same thing, but the mere fact of engaging in the fact-finding process, or I guess it's a legal conclusion of need, whatever that is, isn't that inherently discretionary?
I think there's no doubt that it's inherently discretionary. but at the end of the day, the choice is taken away. The need, you still have to make the determination of need, but you ultimately can't say no because it's mandatory once need is found. The judge can't say despite...
Mandatory to issue an interlock.
Right. Or no, mandatory to issue the conditional hardship
I mean, a conditional
license.
right.
So while there's a determination of need, the judge, and if the judge doesn't want to do it, they still have to issue the conditional hardship. That's what I'm saying. Despite need.
Senator Lombardo, you can continue.
No. I'm lost because if there's a finding of need, this mandates that the hardship be ordered.
Yes.
So why is that problematic? Because we've gone through the process of determining need. Okay? The judge, the magistrate, listens to the facts and decides, okay, you've got a refusal problem. We understand that. We will deal with that down the road through a hard suspension. But you get this conditional hardship now because I find that you need your license. Now, you can't drive at 2 a.m., but you can drive from 7 a.m. until 7 p.m. every day during the week. So I'm confused.
I think there's two issues with that. One's a policy issue. The Attorney General doesn't believe that conditional hardship should be on the table at the preliminary
No, I'm
point.
aware of that.
Okay, that's one. But two, even if there is and I might be stating this wrong, and if I am, I'm sorry for that. Even if there's a finding of need, the judge may not still want to issue the conditional hardship, and this bill would make them.
Well, I think that's the point, though, isn't it? I'm sorry. I'm sorry. I think that's the point, though, isn't it? I mean,
I absolutely agree that it's the point of the bill. We just don't agree with it.
Oh, okay.
That's all.
But okay.
Senator Aptakis.
Maybe this is the second offense or third offense. Is this tied with the hands of the judge on this decision?
Well,
the judge can use past history also, right, to make that determination. And like you just said before, well, the judge might allow this individual to drive between 8 a.m. and 6 p.m. to go to work.
Well, when you look, and I don't want to answer that question wrong, and I certainly don't want to do it with Senator Archambault not here, but the bill does provide for circumstances when there has been priors in there, and it does provide for situations when the blood alcohol is at a high level. I'm not sure how that impacts the preliminary suspension that I'm speaking about, but Senator Archambault does put in here more significant hard license losses for the scenarios you're speaking about. I don't think that applies to the preliminary that we're talking about, but he does have those protections in the bill for other issues.
You can continue, Joey.
And I just have two things more to point out to the committee. On page 14, lines 3 through 4, this speaks about interlock provisions on an 18.1. And we just wanted to clarify in here, it says, for a period of 6 months subsequent to the penalties enumerated in 18.1. Is that subsequent to the fine? If there's a term to serve, is it subsequent to that? Or if it's a year probation? We don't know really how that works out, so we just think there should be clarification there. And then finally, our last concern is on page 15 at the bottom, and that's subsection B. Right now, and I think that I can see the concern from Senator Archambault's point of view, and I certainly know the concern from our point of view. Right now, the Division of Motor Vehicles prior to reinstatement looks at the operator's use of the interlock system. And they consider how they've complied with that order. Have they blown over every day throughout the interlock order? Have they blown over 20 times a week? And they take that into consideration when reinstating the license. And that language is found when it says, and conditions have been demonstrated behavior that warrants the reinstatement of the license. From our reading of this subsection B, the license would have to be reinstated as long as the interlock was on the car from for the amount of time ordered by the judge or the magistrate. There would be now no view of how the performance under the interlock order was. And we do have some concern with that, not so much in a criminal point of view because the person is on probation, but in the traffic tribunal point of view. The traffic tribunal has no jurisdiction over their sentence or no ability to violate a person technically if they're continuing to drink and blowing over their interlock order.
However, but if they're blowing over, the interlock won't allow the car to start, so they're being penalized there, I would think, aren't they, and being able not to drive?
Well, I think buttons. They are being penalized for not to drive, but the issue of them trying to drink and drive has not been changed. So I think there's a difference between blowing over once or blowing over every day for the entire time of the interlock order. So we would like some discretion in that. We don't think the bill as written addresses that.
You can proceed.
That's all I have, Chairman.
And all the bills?
Yep.
Joey, you can proceed.
Thank you, Chairman and members of the committee. On behalf of the ACLU, I'm here to thank Senator Archambault for really positive work on a lot of issues related to these drunk driving penalties that are in the law currently that we've had some concerns about for quite a long time. Like Joey, I'm also going to speak to 2370 and 2372. We feel that this is a really important positive step towards enabling people who have had their first time low-level drunk driving conviction to rehabilitate, to continue their lives in a positive way. The way that the hardship license stands now, you can really only get the license to go to and from work, which is helpful, but it's not particularly helpful if you are a single parent who needs to take their kids to school, if you are somebody who needs assistance getting to your AA meetings, if you have doctor's appointments, et cetera. And so we see these bills as a positive step towards enabling those individuals to continue their lives in a positive direction and to work toward their rehabilitation. With that, we thank Senator Archambault for his work, and I can answer any questions that you have.
Are there any questions for this witness? Thank you. Mr. DeLauro?
Thank you, Mr. Chairman and committee members. I'm here to testify in support of two of Senator Archambault's bills, 2371 and 2374. They appear to be identical, so my testimony is identical with each of them. I can describe the bills for the committee. What they would do is for operating with a suspended license, someone who does that, the first two would be reclassified from misdemeanors, as they currently are, to civil violations. And from those, the provisions regarding a further suspension of license would be removed. The third suspended license case would remain a misdemeanor. There are also some provisions regarding expungement that I'll talk about in a couple of minutes. The idea of reclassification is something that we've been coming up here now for the last several years and asking that policymakers engage in a conversation about the costs of criminalizing certain conduct, whether or not that cost is justified by an uptick in public safety, and finally throwing also into the mix the issue of collateral consequences which may be, in some instances, for a lifetime. We think that it makes sense to engage in that conversation, and that really these two bills are incredibly well crafted and thoughtful. So at the national and state level, there has been an ongoing conversation now for several years about the over-criminalization of conduct. And strangely enough, it's the Republicans who seem to be speaking in support of that most often. That kind of comes out of the fact that some things in the regulatory field become criminalized, and they want to address that. Our concern is more for the individuals who fall within the clutches of our criminal justice system and perhaps are better treated somewhere else. We know that the Council of State Governments has been here in Rhode Island assisting the justice reinvestment effort, and of course they have found that, among other things, that Rhode Island is number 2 in the nation per capita with the number of folks on probation. Now, as a practical matter, folks who are getting suspended licenses are not now getting probation, but we think that it starts folks down that road to becoming involved in the criminal process. Reclassification is not something new or radical. This body did that several years ago when it reclassified possession of small amounts of marijuana as a civil offense. And as with marijuana, this bill makes the very same judgments that legislation did. What I mean by that is, with the marijuana law, repeat offenders are that would be, in fact, civil violations. They do indeed become misdemeanor offenses, and also possession of certain amounts of marijuana remain misdemeanor offenses. We think that is exactly what is done with these two bills, because first, repeat offenders, the civil violation serves as a predicate to make the subsequent offense a misdemeanor. And also, and again, this is why this legislation is so thoughtful, we think, that folks who are, what's called an 18.1, meaning that their licenses are suspended for alcohol-related type offenses, do not come within the umbrella of this legislation. So that's why I say it's very carefully crafted. We do think that on the second page, the provisions on lines 24 and 25 regarding expungement might stand could stand some tweaking, but other than that, we think this is a great idea whose time has come. I seem to remember, too, the Senate passed some version of this maybe 2 years ago. Could be my memory's wrong, but I seem to remember that. So with that, I'll answer.
You don't happen to know the crafter of this artful legislation, do you?
It wasn't me. I can say that for sure. That I know for sure, Mr. Chairman, because that expungement part would have been perfect.
Are there any other questions or comments? At this point in time, I did receive a text from Senator Archibald. He should be up here in a few minutes, so I'm just going to ask that the committee stand at ease for a couple of minutes so Senator Archibald can come and speak on his bills this evening.
Those are the only two that I was going to speak about.
your bills, Senator, and there were some questions from the Attorney General's office on the 2370 and is it 2372? Maybe if Joey, if you can come up, and Steve may be able to explain his intent with respect to those changes.
Thank you, Mr. Chairman.
I thought so. Hi, Senator.
Hi, Joey.
How are you?
I'm well, thank you. How are you?
It's a pleasure to see you.
Always a pleasure to see you.
Her concern, Steve, on the first bill was on page 3, I believe it was, the given the discretion or taking the discretion away from the courts relative changing the may to a shall after the eligibility criteria.
Thank you, Mr. Chairman. You want me to? I'm grateful, Senator Lombardi. Let me address that.
Frankie hasn't published the book yet, or we would have been all set.
That's all right. I was more lengthy downstairs in the Health Committee. I'll be a little bit more brief here. So let's just go back a little bit and give a little bit of context. You know that I prosecute, and you know I do for a few different towns, and I do defense work. And so when the first bill was written 2 years ago, and I used Massachusetts as the model on the hardship provision, I had vetted it with defense attorneys, prosecutors, people I won't name in the AG's office, and judges, and anyway, and we came to this bill that was designed to, with the approval of MAD nationally, protect people by using the interlock. That's the only way you could get the hardship, and by letting the hardship provision help people to keep their jobs. I used the word may because I had faith in judicial discretion. I've talked ad nauseum up here about judicial discretion. After the bill was implemented, I found that some judges were saying, I'm not doing it at all. Other judges were saying, I think you got to have a strict mandatory minimum period of suspension. Still other judges were doing what the bill intended. I found myself doing my defense and prosecution in front of some various judges, and I said, well, you know, I wrote the bill, so I can tell you what the intent is. And they'd listen politely, and then the lights were on, but no one was home. Okay, just being as honest as I can, because as soon as I finished, well, I wear the black robe, and I respect that. This isn't a slight. You know, the faith I have in our judges, you don't have uniformity in its implementation. That's a problem. And still, other judges came back to me and said, this bill really does need to be cleaned up. You've got to clean up some of the provisions. I had members of the Attorney General's office saying to me, wait a minute, some judges are doing this, other judges are doing that. So we make it shall. You shall give the hardship. Then we took a look at the carve-outs. One carve-out is that if you've got aggravating factors, motor vehicle accident, that's the most common thing I see. I had a couple of DUI pleas today I was prosecuting on. Car accident, got an accident. You've got a reckless driving conviction. It's not easy to get a reckless driving conviction. You get a reckless driving conviction, I don't have much sympathy for you. 31-27-4. Reckless driving conviction. Or an alcohol-related offense within 10 years, another DUI. The punishment can be enhanced on the suspension, up to 3 months loss of license if it's BAC, blood alcohol content of 0.15 or under. If it's over 0.15, you can give up to 6 months loss of license. And frankly, as you know, because you prosecute, that's the way we do it at the courts now. That's pretty much the standard. In fact, I had a case today as a defense attorney after my prosecution where I had someone with 2 DUIs, and we reached an agreement on 6 months hard loss of license, and then there'd be a hardship provision thereafter and a lengthy interlock period. And that plea will mirror the spirit of the changes in this law. So I had a lobbyist approach the other day and talk about there was some grumbling about the judges on discretion and, you know, take away their discretion. And I shook my head. I thought, man, this is one of those bills that, having thought it up in my head and vetted it and having written it and having received a lot of really positive reviews, the last thing in the world I expected at the 11th hour was some judicial blowback that some discretion would be taken away. So my response would be shame on the fact that shall has to be written on there and that there hasn't been uniformity across the board. I'll take my responsibility for that. Perhaps it should have been shall from the onset. If it were to stay may, you'd have arbitrariness in the implementation of pleas. Some judges, I said, not even doing this. Other judges going beyond what the statute would allow because that's their nature, and still a core of judges actually following it. This bill will clean it up. Everybody will be on the same page. It's a good bill. Mothers Against Drunk Driving nationally support this bill. It's a very positive bill. Well, that's my 5 minutes longer than I thought I would be response. So I'm open to any questions you might have, Joey.
I understand. Our concerns are conditions. I feel like I was just talking to him personally. I'm sorry. I was in my own little zone with Senator Archambault. Our concern is the granting of the conditional hardship at the preliminary. We have a serious concern with that. We also share the concern of discretion, and I know we're going to immediately disagree with that. So we do share that concern, just in the fact of on the Superior Court calendar, some judges would offer 8 years to serve on a case, and another would issue a year to serve. We do have issue with that because we agree there should be discretion, but we think there should be discretion on everything. So that was our
Wait, let me interrupt you for a second. Then we shouldn't use the word shall in any statute, right?
My understanding that many of the people in my office, the Attorney General himself, in this body, all agree with we shouldn't use shall in many instances.
No, I disagree with that completely. Certain things should be shall, but we can agree to disagree and move on. Let's go back to that other part, though,
yes.
because you're talking about the preliminary order suspension. For those of you who aren't aware and don't know, that's relative to the traffic tribunal. Let's put the courts aside for a minute. District Court, Superior Court. At the traffic tribunal on a refusal, the first thing, because your license is a privilege and not a right, you don't enjoy the same constitutional rights to due process. So essentially, once you go to your first hearing, there's a preliminary order of suspension that's entered if the judge reads the affidavit, State v. Link, and they see in that affidavit that there's enough reasonable suspicion and grounds to believe that the individual was driving while under the influence, was impaired to a point that rendered them, under the statute, incapable of safely operating the vehicle. Then you grant the preliminary order of suspension. I just want to be clear on this because there's a whole bunch of arguments in the back of my head that I'm going to be more of a listener than a talker here. Can you amplify on what the argument would be against the implementation of the hardship in favor of a preliminary order of suspension and juxtapose that with what the difference would be with the district courts where you could do it in the first instance in a criminal court that's a higher court? Just help me on that.
Senator, our interpretation of this law has always been that the granting of the hardship license is in play with the installation of an interlock system.
Absolutely, agree.
At the preliminary suspension, there's going to be no indicia of that. And that's our concern.
Well, but let me stop you for a minute, Chairman. Let me stop you for a minute. You know, I haven't seen a traffic tribunal judge who's going to give the hardship license without the interlock. I mean, that's the way the law is written. You can't get the hardship without the interlock. And I wrote that bill so that you had to do the plea. I didn't want to envision. I vetted this with my brothers and sisters who do a lot of this stuff. And as I said, the other body, collective body, so that we avoid it in the law, situations where you get all these defense attorneys running in and saying, "Oh, wait a minute, can I get a hardship license and then we'll continue to pre-try the case?" That's a recipe for disaster. Former Judge Senarini once said to me, a great comment. He said to me on a filing, I said, "No, I'm going to offer a 6-month filing." He said, "Hey, what's your approach?" He calls me up to the bench. I shouldn't mimic voices. He calls me up to the bench. He says, "You want to give a 3-month filing? How about a 2-month filing?" You get my point. That there are certain instances in the law where things should be absolutely done at the right time. You don't want to grant the hardship license prior to a plea because you get attorneys coming back in trying to take advantage of the system, I think. And I see enough of that weekly. I really do. So to answer your question, the preliminary order of suspension, if it's granted, say the traffic judge says, granted, preliminary order of suspension, and right there at the arraignment, a defense attorney's done their due diligence. They've gotten their police report, all this is uncommon. But just say at that early juncture, hypothetically, they've gotten all their discovery. The police report, they've called Al Giusti and checked that they've made sure everything's in line on the officer, all the pieces are in place, everything's the way it's supposed to be. Well, typically it wouldn't be Giusti because that would be when there's a BAC reading. But just say initially at the preliminary order of suspension, they've done their due diligence and they want to enter a plea now. In order to enter that plea, you have to have the interlock. So typically you come in, you pre-try the case with the judge, you work out an agreement. I did this yesterday. I pre-tried a case yesterday on a refusal as a defense attorney. I reached an agreement with the judge and the prosecutor for the AG's office, and we're going back next Wednesday when my client will have the interlock installed. I'll have proof that the interlock was installed, show it to the judge, give it to the clerk, it's filed at the DMV, client's all set, and then the client is able to start driving. Of course, in this case, there isn't a hardship. But were there to be a hardship, then I provide proof. Here's where the client works. Put your hand up. Testify under oath that the individual's really working at that place. This is a legitimate job, and the hardship's going to be relative or restrained to just the hours within that job. And then the judge has the discretion to grant that hardship if they believe the testimony. That's the way it's supposed to work.
Senator Lombardi.
Senator Archibald, can I ask, because you just raised a question in my mind, because prior to getting here, I had advocated on your behalf, not that you needed me to advocate for you, but now there's a question, I presume, in response to Joey's question, the lawyer, the defense lawyer who does his due diligence at the preliminary phase, at the preliminary suspension level, is prepared to ask for the hardship at that point, and is also, therefore, probably has done his due diligence by instructing his client to install the interlock.
And yes, and that would be an anomaly. That's the exception to the rule.
Right. But now here's my problem, because I believe that there's still discretion in this bill, because there's an inherent discretion that the magistrate has to find the need. Put that in quotes. What if that zealous defense lawyer does his due diligence, installs the interlock, is prepared to ask for the hardship license, but then the judge or the magistrate finds that there's no need?
Well, the judge finds that there's no need, then the judge finds that there's no need. And that would have to be based upon the testimony of the defendant. Or I do. There's some potential for abuse there. Yeah. I'm concerned with that. I thought beforehand about that hard, and we talked about this when we were drafting it, that there's some potential for abuse there. And I would hesitate to think that we get judges who would say, you know what, I know a way around this. I'm going to, at the preliminary order suspension, say that you don't qualify for that hardship provision. But, I think there's enough astute defense attorneys out there to quickly take that up on appeal.
I'm sorry. I fully support your intent. I mean, we talked about, we finally got, in your absence, Joey and I finally agreed that we just disagree on the pros of the intent of the bill. I happen to support your intent of the bill. I think what we're trying to do here is get someone who is, who is unfortunate, has been found to have violated the law regarding refusal to submit to a chemical test, and therefore subjected to a preliminary suspension of their license. The goal here is to not further exacerbate the condition by not allowing this person to go to work, not allowing this person to go to medical, and all of that. And so I fully support your intent. I think it's a great idea. This question was just raised. If we do it at the earliest possible time, you would have to anticipate what a magistrate's going to do regarding need by having your client install the interlock.
Well, and that let me
that's my problem.
Thank you. And that gets to whether or not a defense attorney would actually be prepared enough at the initial arraignment to have an interlock in place. You know, sometime in the past, I've seen certain defense attorneys with no discovery plead people out at arraignments in DUI cases. Absolute malpractice. And you sit back quietly because we're a bar, and I'm scratching my head thinking, oh, my God. And probably 1 in every 4 DUIs, and this comes from a prior police officer. And, you know, there's problems. There's problems with either the observations or the issues. And I'll go as far as to say 1 in 4 there are issues with. 1 in 4, 1 in 5. And if there are procedural issues or substantive issues, we shouldn't just assume that even if the person was impaired, that the safeguards of our Constitution and the Fourth Amendment should be thrown out the window, yet you get these defense attorneys who come in and they, oh, yeah, okay, guilty, Your Honor, we'll take that minimum off, and they walk out. And usually I'm sitting with my brethren who we look at each other, we say, you believe that guy just did that or that woman just did that? I think it's an anomaly to have an attorney come in, Senator, at a preliminary order of suspension level at the initial arraignment and actually have all their paperwork in place. But to respond to Joey, if they were to do that, if some time went by and in 2 weeks you got all your discovery and you did all your research and you had everything in play and you're ready and you have the interlock and you're ready to address the hardship, why shouldn't you be allowed to? I guess my question to you, Joey, would be, what's wrong with that?
We've talked a lot right now, so let me kind of backtrack a little bit. So what you're saying, because I want to get where you're at on this, you're saying I go in with my client, I go to the preliminary suspension, I have got the interlock set up, I'm ready to go. Do I plea him in that day, him or her in that day?
Well, let's go with a hypothetical. Let's say, as you know, in most instances, this doesn't happen. This is the exception to the rule. But let's go with the hypothetical that you've got an attorney, gets a call, gets a client, arrested for refusal, DUI. A couple of weeks are going to go by before they come and have the arraignment for the refusal. In those 2 weeks, the attorney gets the discovery from the respective police department, does their due diligence, and realizes that I don't really have any substantive or procedural arguments for defects here. I've got a client that was operating under the influence. Ultimately, I'm going to enter into a plea. I don't want them to lose any time at their job. I don't have any aggravating factors. I don't have an accident. I don't have prior alcohol. I don't have a reckless driving conviction. I don't have any of those aggravating facts. I have a garden variety, almost vanilla type of low-level DUI. Demands just as much attention for the interlock and the safety of our public, but on a 1 to 10 scale, I'm sort of down here at the bottom. So that lawyer decides with their client that I'm going to go out and I'm going to get an interlock, and they go and they get, at their own risk, because they don't have any court authority just yet, they go and they, Senator, you see how arbitrary this would be? They go and they get, or how much of an anomaly, excuse me, how this would be the exception. They go and they get the interlock installed, they get the paperwork for the hardship, they get to the preliminary order of suspension. They say, Your Honor, we want to enter into a plea. Okay. Everybody agrees on the plea. They agree. Say, Judge, I have the interlock. All right, you got the interlock. Okay. How about, yep, here's the proof. He works at XYZ company, 9 to 5. I've got the proof right here. He works. He's going to testify to it. Okay. Judge puts him under oath. He testifies. Okay. What's wrong with that?
Senator Lombardi.
I guess, again, Steve, you're right on target. I think we should be able to get them this conditional hardship license at the earliest possible time. I think now that I think about it, and I talked to the chairman, the only anomaly I see is at the traffic tribunal, because that's the area where it's the earliest possible sanction, the preliminary order of suspension. And I just don't see how. Well, I see what you're saying, but I just don't see at a refusal where you're facing a preliminary order of suspension that you're prepared to have the interlock in and then presume that the magistrate will say, and it's probably never going to happen, Steve. I understand. And I think, Senator, I'm sorry, but it's probably never going to happen. But I think the words really come down to at line 7 on page 13. it says, immediately upon plea or admission of guilt, no problem. Or an initial suspension under 3127 2.1. That language, the initial suspension, you're obviously talking about refusal and the preliminary order of suspension. I mean, I wish it would happen, and I wish I would be the lawyer that could do it. But I just don't see how we could presume to install the interlock, go before the judge the first time on a refusal. The judge is prepared to order an initial order of suspension under the statute, and then you say, Judge, I'd like to be heard on need. You present the case of need, and then the magistrate says, okay, I've heard you, but I don't find need. Now you've got a client with an interlock installed in anticipation. So that's the only area where I see that it's going to be a problem. Do I think it's ever going to happen? Maybe 1 in 1,000 times, because I don't think that there's any way we're going to be at the traffic tribunal ready, willing, and able to have an interlock in place and establish need at that point. I think, 2 weeks down the road maybe, or a week down the road, which is fine. I mean, it's only a week or two without the car. But I get you wholeheartedly. I think hardship should be given. If the reason for the hardship is to protect people's jobs and that sort of thing, not to give them the right to drive whenever they want to. So it's that initial language, the initial suspension language. I think could present a problem. I'm not saying it will, but it could. And I'm also saying it's unlikely that it'll ever occur. But I think that's where I'm going.
No, Chairman?
Go ahead, Senator
I understand, and I understand, and I get the initial inquiry by the Attorney General's office here, but the thing I was trying to avoid was an abuse of the use of a preliminary order of suspension as a way to circumvent the statute, because you don't have all judges on the same page already, and some don't want to do it. And we know that. We all know that sitting here today. And, look, we're legislators. We're not judges, right?
It'll be that very magistrate who will decide, they've got a problem with not giving a hard suspension, at least some sort of a hard suspension, and just finding there's still that inherent discretion about need in there, and saying there's, I don't find need.
Thank you. Joey, let me probe your inquiring deep mind. What are your thoughts? Tell me what you've touched on it. What do you think? What do you propose, Joey?
She wants it 6 months down the road, Steve.
Talking through. When you talk about the plea, I don't have an inherent, Joey, I don't have an inherent objection to that, and I don't believe my office does either. My concern is when we have language right here that talks about upon an initial suspension, that your scenario of plea at initial suspension, interlock in, a judge may use their discretion and say, oh, according to the refusal statute, I can do this in accordance with 2-8, and it says I can grant conditional on an initial suspension. I don't even need to worry about the interlock being installed. That's my concern. So I know we're all looking at hypotheticals, and that may or may not happen, but we are very concerned with the conditional happen without the plea and the interlock installed. That's all. That's where my brain's at.
I understand. You can't have the hardship without the interlock, so you know that.
I'm just concerned. I brought up about just about how we're looking at this and what they need. That's all.
I understand.
I don't think.
Joey, maybe you can work with Senator Archibald to address some of those concerns.
Absolutely.
Senator Archibald, do you want to vote in the affirmative on the legislation that we already voted on? And Senator Nesselbush, without objection, so ordered. At this point in time, Senator Archibald moves to hold for further study bills 2117, 2123, 2371, 2374, 2372, and 2370. Seconded by Senator Lynch. All in favor signify by saying aye.
Aye.
Opposed? They're held for further study. Senator Conley moves that we adjourn. Seconded by Senator G. All in favor signify by saying aye.
Aye.
Opposed? We're adjourned for the evening.